Get ready for the dictation. Start. In this appeal, the counsel for the appellant bar plaintiff during the course of his arguments has contended that defendants 1 and 2, being the original owners of the suit schedule property, have executed an agreement of sale dated 12/9/1995, in favor of the plaintiff agreeing to sell the same for Rs 35,000 and receive the entire sale consideration amount and put the plaintiff in possession of the same in part performance of the agreement of sale, full stop. Despite several requests made by the plaintiff to execute the sale deed, the defendants 1 and 2 postponed the same on one pretext or the other, necessitating the plaintiff to cause legal notice dated 18/11/1999, full stop. The plaintiff having always been ready and willing to perform his part of the contract, has filed the suit for specific performance of the agreement of sale, which came to be dismissed by the court below by passing the impugned judgment and decree, which is not maintainable either in law or on facts, full stop. The court below erred in holding issue number 1 to 4 in the negative, though the oral evidence of PW1 to PW3 is corroborated with documentary evidence marked as Exhibit P1 to Exhibit P3. The court below is not justified in dismissing the suit, holding that in the cross-examination of PW1, he has deposed that defendants 1 and 2 agreed to sell the suit schedule property because, they were in need of money in the year 1995, but in order to prove the said necessity, the plaintiff has not at all produced any material, full stop.